Hi, my name is Joanne Lowy, and I am the Local Board Relationship Manager for PSPRS. Welcome, and thank you for attending today's Open Meeting and Public Record Law training session. This training is required for new local board members, secretaries, and council elected or appointed on or after January 1, 2022. There's a lot to open meeting and public record laws, and while we'll cover a good deal of it here today, we recommend reading the law and other resources to ensure you have a full understanding of your responsibilities as a local board member. Let's get started. First, we'll summarize the intent and most basic requirements of Arizona's open meeting law, which is commonly abbreviated to OML. The intent of the law is to ensure that government is accessible to the public, that government decisions are made in the public, and that the public has adequate notice of and opportunity to lawfully influence government decisions. With that, there are several basics. The public must be given at least 24 hours notice of a board meeting. The public must be given details of what will be considered or decided through an agenda. To vote in a public meeting, there must be a quorum, which is a majority of a government body. If a quorum is present, then it is considered a public meeting. So be mindful when meeting with fellow board members outside of formal meetings. Remember, as a board member, it's the law to know the law. So when in doubt, err on the side of caution. So who must follow open meeting law? Well, the law applies to all members of public bodies, including local boards, which are entities that are separate and distinguishable from an employer. For the purposes of this training session, our discussion will be limited to local boards, but requirements are universal for governments in Arizona. Please note that the open meeting law does not apply to internal staff meetings or to meetings or conversations with individual board members. One of the first and most important requirements of open meeting law is to provide official notice to the public at least 24 hours in advance of a meeting. Under state law, notices must be published to an agency's website and posted to an accessible public place, like the physical location of the meeting. A notice must include key information: the local board's name and the date, time, and place of the meeting, the agenda or how to access a copy of it, and whether the meeting could include an executive session. Notices may be combined with a formal meeting agenda, and here's how we do it at PSPRS. Meeting dates are scheduled at the beginning of the year and published on our website, and then updated as needed. PSPRS then posts official notice for each meeting, sometimes weeks in advance. PSPRS notices include the possibility of an executive session as a precautionary measure if an executive session is needed. Now let's move on to agendas. Like meeting notices, agendas must be posted at least 24 hours before a meeting. The agenda must include specifics on what will be considered or decided. The agenda must include a note if it is revised at any point. Agendas may include consent and executive session agendas. Consent agendas are used to save time. They allow the board to vote on several items at once, and this is used for routine or administrative matters. An executive session agenda must include a general description of the matter and cite the specific subsection of the statute that applies. We'll touch on executive sessions in greater detail in just a bit. Now let's talk about the public's right under open meeting laws. An open meeting means the public can attend and record the meeting. While the purpose of an open meeting laws is to ensure open government, at the discretion of a board, the public does not have the right to speak at a meeting or to join in on discussions or be disruptive. Now let's talk about board members. Board members can consider and decide items listed on an agenda. Be mindful that items agendized for discussion cannot lead to a board vote. To vote on a matter, a board must agendize an item for possible action. Board members can also invite the public to speak through a call to the public. When doing this, a board can set ground rules. This can include time limits, directing groups to appoint a spokesperson, or other rules to ensure that a board can get through a meeting agenda. Boards can respond to the public if there are comments directed at the board. A board can also direct staff to look into a matter or vote to postpone any decisions or actions until the next meeting. All right, so let's talk about what board members can't do under Arizona's open meeting laws. Board members cannot circumvent open meeting laws by engaging in private conversations about a pending matter with a quorum of board members. The practice of contacting multiple board members to influence decisions or count votes is called serial communications. Serial communications are illegal under Arizona open meeting laws. Boards are also prohibited from engaging in viewpoint discrimination. In practice, viewpoint discrimination could include forbidding individuals from speaking during a call to the public based upon a speaker's viewpoint or belief. Local board members may not share confidential information or discuss or take action on matters that are not on the agenda. Board members must also disclose any potential conflicts of interest and must recuse themselves from votes on matters in which a conflict exists. This could include voting on a family member's disability retirement application or failing to disclose any relevant personal or family business interest during procurement considerations. There's an exception to prohibitions on conflicts of interest, and that is when the majority of the board has a conflict. That scenario would be rare, but a board can proceed with a vote if board members state their particular conflict of interest on the record. Arizona's open meeting laws put some important and well-intentioned restrictions in place for local board members. There's also a very reasonable exception when it comes to board members expressing their opinions. Board members are entitled to express their views at public events, in conversation, and through media, but they must be careful of the law. They may not direct any comments at other board members. They may not engage in deliberations with other board members or take any legal actions outside of a public meeting. When expressing an opinion publicly, it is good practice to disclose any issues that are or may be going before the board, respect other board members and their opinions, avoid suggesting or predicting outcomes. Avoid the appearance of speaking on behalf of the board without authorization. Now that we know what members of the public and board can and cannot do, we're going to move on to how boards are required to take and publish meeting minutes. What transpires in a board meeting must be documented in the form of written meeting minutes or audio or video recordings. Draft minutes or recordings of minutes are required to be made available within 3 days. Minutes must include the same event information required for notices and agendas, as well as the following: a list of members present or absent, a clear description of all legal actions proposed, discussed, or taken, and who proposed and seconded each of them, a record of how each member voted and any statements or presentations shared, a list of any issues discussed that were not part of the agenda, most likely during a call to the public. Next, the minutes will be finalized and approved. The approved minutes must be posted within 2 days of board approval and be made available online for at least 1 year. They must also be retained according to state record retention requirements. There is one exception, and that's executive session minutes. That brings us to executive session requirements on the next slide. Executive sessions must be announced to the public. If there's no executive session on an agenda, an executive session cannot happen. It's that simple. An executive session may be combined with a board meeting notice or agenda. PSPRS, for example, issues public meeting notices that include a notice of executive session and provides additional details in meeting agendas. As we continue, an executive session agenda item must also include a general description of all matters to be considered. It must also cite the specific section of Arizona's open meeting laws statute that authorize the use of executive session. There are 7 purposes for government bodies to use executive sessions. Most local boards typically hold executive sessions to review or discuss confidential health-related information for disability retirement applications or to obtain legal advice from attorneys. There is a very specific process for entering and exiting executive sessions. First, a motion must be made and the reason to enter an executive session must be clearly stated. The members then vote to enter the executive session. The chairperson is responsible for directing the public and all non-essential staff to exit and take their belongings with them. Executive session attendees are reminded by the chairperson that the session is confidential. The session is conducted and adjourned to return to regular session. Please note that boards are prohibited from voting or taking action during executive session and from polling members prior to a vote in public session. After the board exits the executive session, they may vote or take action again on the public record. This can include voting on benefit applications, contracts, negotiations, litigations, or other discussions. However, the board should be careful not to share any confidential information or advice received during the executive session when calling for a vote in the public session. That would defeat the purpose of the executive session. Now let's talk about executive session minutes. Overall, the executive session minute requirements are no different from what is required for public session minutes. Executive session minutes must include accurate descriptions of what was discussed and any instructions given to attorneys and designated representatives. The big difference is that they are confidential and can only be disclosed to other local board members, any person who is the subject of a personnel matter, staff as needed to prepare minutes, local board's attorney to provide legal advice, the Auditor General, the court, Attorney General, or County Attorney in connection with the performance of their duties. And now we'll move on to public records management. A local board is responsible for maintaining its public records. Records are presumed to be public and must be turned over promptly in response to public record requests. But there are more than 300 statutes that address confidentiality of records, so you do need to be careful. Inconvenience or embarrassment is not a justifiable reason to withhold records. Common reasons for confidentiality include attorney-client privilege and privacy. Local board members and secretaries should remember to consult with your attorney if you have questions. Work with the public or media to narrow the scope of a records request. Redact confidential information from records and avoid blanket refusals. Furnish a privilege log when requested to explain why any records were withheld. Refusal to turn over records can result in lawsuits. And finally, if a denial is determined to be wrongful, the board may incur costs for damages or attorney's fees. Which brings us to violations, enforcement, and sanctions. Many, if not most, violations of open meeting laws are unintentional. Any actions taken in violation of open meeting laws are non-binding. A board must reconvene to ratify an invalid action within 30 days. Regular notice and agenda requirements apply. However, ratification notices must be posted 72 hours, not 24, in advance. Once complete, the ratification validates the action and preserves the earlier effective date. However, ratification does not eliminate individuals' legal liability for violating open meeting laws. In such cases, members of the public may file complaints with the Arizona Attorney General or the Arizona Ombudsman's Citizen Aid Office. The Attorney General is authorized to enforce open meeting laws through court actions, and violations are assessed against individuals, not government agencies. Note, this could result in fines, legal expenses, removal from office, and/or payment of the plaintiff's legal expenses. And finally, I must remind our audience that this presentation is intended for training purposes only and not considered legal advice. Local board members are encouraged to read Arizona's open meeting law and consult with their attorneys as needed. Thank you for attending this training session and serving your community by joining your local board.